Well, thank you. Good to be here today. As Ian mentioned, I am on the board of directors here at Hospice, and on behalf of the board of directors, we certainly appreciate everyone's attendance here today and support of Hospice for this event. We do have some other board of director members. We have Ertel and Rodney Cox over here, and I don't know if I see any of our other board of directors, but anyway, we appreciate it. And the focus of my spiel today was going to be powers of attorney and estate planning documents, which I understand have been somewhat dealt with and addressed already this morning. So also I want to discuss some of the advance directive options out there, and their different utility and the importance of having those documents properly executed and on file with your healthcare providers and healthcare facilities. I was here for Mr. Cuckie's speech, and so I'm just going to go ahead and start with powers of attorney, which there were some questions that I think I can help address as part to kind of supplement what he presented to you all. First, I think you all know power of attorney is your during life designation of an agent, and you are granting that agent the authority to act on your behalf in certain roles, whether that be more of a financial power of attorney or a medical power of attorney. One question that was presented to Mr. Cuckie was, can I place in restrictions, or are there different types of powers of attorney? Yes. You very commonly hear the term durable. A power of attorney does not have to be durable. What that term is very specifically referring to, if your power of attorney is a durable power of attorney, that means it survives your incapacity. Okay, so if you execute the power of attorney now, you're of full, sound, legal capacity to execute documents, and later down the road, whether it's due to an acute accident, a medical event, or if it's due to a slower progressing cognitive related ailment and you become incapacitated at some point, that document is still good. And those individuals that you nominated in that document can still serve in their capacity of power of attorney because you executed a durable power of attorney. If your power of attorney is not durable and later on you are adjudicated or deemed incapacitated by your medical care providers or the court system, your power of attorney is no longer valid. Okay, so if in the event you want somebody in that role during your incapacity, you need to have a durable power of attorney. So there are other powers of attorney that we call springing powers of attorney that don't come. They have no legal effect until you are deemed incapacitated. Okay, so there are different variations that can create different restrictions. And so, looking at not only getting your power of attorney done is very critical, but the different options out there. From our perspective, we greatly encourage our clients to do durable powers of attorney. That gray area of are they incapacitated, are they not incapacitated, leads to a gray area, and individuals who sometimes really need a power of attorney, their power of attorney is not yet effective because doctors are not always very willing to say yes, they are completely incapacitated. So in particular with the slower progressing cognitive disorders, when a doctor comes into your home and they see you in a very small window, they may feel in the moment that no, you weren't incapacitated. Your loved ones, on the other hand, may say, well, if you were around them 24/7, you would know. But sometimes those different ailments are difficult for somebody to come in a 15-minute conversation with you, truly be able to give a medical opinion as to whether or not you're able to make sound decisions and whether or not you should have a power of attorney. Personally, I believe if you trust somebody while you're incapacitated, trust them while you're of full capabilities. Sign the power of attorney, make it durable, and remove the gray area. Did I hear a question? Sorry, I'll kind of just keep going. I'm an attorney. I like to hear my voice. So you just raise your hand, tell me to shut up. I'll address questions. And these different variations, the durable, the springing power of attorney, that's applicable to whether or not we're talking about a durable or a financial power of attorney to handle your bank accounts or your property matters, or your insurance matters, your vehicle matters. That also applies to your medical power of attorney. Those two agents, those two roles, do not have to be the same individual. It's very common for me to speak with individuals and they have one trusted person that's maybe a little bit more geared toward the financial world and they have a better understanding, and they have another individual that's maybe a little more geared toward the medical and the healthcare providing aspects of their life. So specific to powers of attorney, I know, like I said, I know they've been discussed. I don't really want to just sit here and belabor powers of attorney. Are there any questions related to them? Yes?
So you're saying that a durable power of attorney can serve as a medical power of attorney and a financial power of attorney? Does it mean to be?
Those are two different documents, but yes, you can have a durable medical and a durable general financial.
Okay.
But it's that
But it has to be specified.
It has to be specified, yes. And I mean, of course, there are also, and you can put any amount of limit on a power of attorney. You don't have to, when we talk about general, I mean, we're talking about if you've got a durable general medical power of attorney, you are giving that person a very broad power to handle any medical related matter. Or you can get more specific. You can say, no, I want to nominate this person as my medical power of attorney for a particular procedure. I am often designated as people's power of attorney for a very specific and limited purpose. They're going to be unavailable, and powers of attorney don't need to be utilized always because of incapacity. They can be utilized just because you're unavailable. I have people who, they've got plans, they're going to be gone for a week, but they need to get something accomplished. They can nominate an individual as a power of attorney just to go get their bank loan closed or to go sign a deed so they can transfer their property. They can be much more specific and not so broadly phrased and presented. Any other? Yes?
Personal example, my mother toward the end of life was experienced dementia. Some days she was pretty clear as a bell.
Yes.
Other days, for periods of time, she was kind of confused. So we had a durable power of attorney, but I don't think any medical advisor ever deemed her incapacitated. So,
because it was durable.
Pardon?
Because it was durable.
So, but on those days that she was fluid, could she have conducted business for herself?
The answer is yes.
Okay.
Executing a power of attorney does not take away your ability to act on your behalf. It just gives somebody else also the ability to act on your behalf. So if on those days that maybe she was a little bit better, had she driven to the bank and the bank doesn't necessarily know her current medical or mental cognitive situation, yes, she could have been able to conduct business on her behalf. There are ways to end somebody's ability to act on their behalf, but that's a court proceeding.
So there were times, and it didn't get complicated, but when she was fluid and we discussed things, and where she was informed of what maybe had been done, she may have objected to it. Could she have contested that? I'm not getting out in the weeds, but I mean, could another family member come in and said, no, she's very capable of making decisions and she didn't want that?
It's a little bit harder for another family member, but yes, a power of attorney's decisions can be contested. In Colorado, there's what we call the Colorado Fiduciary Powers Act, and basically first of all, what it says is the moment you decide to start acting in that role of power of attorney for somebody, if somebody appoints me as power of attorney, there's nothing forcing me to act. Okay, I don't have to say, oh, I can say no, I don't really want to do that. I mean, that's why it's a very wise practice. If you're going to nominate somebody as power of attorney, ask them if they're willing to act in that position. But if you nominate somebody and they begin to act in that capacity, Colorado law places a fiduciary role on them where they have to act in your best interests. You have to act as a reasonably prudent person would. And so if somebody wants to challenge your decisions specific to your role as a power of attorney, then we would go back and look at those decisions, and we're not going to pick them apart in hindsight and say, was it the perfect decision? We're going to say, was it reasonable and prudent in the circumstances? Does that make sense?
I have a question.
Yes.
If I become a power of attorney to an individual in full faith that I'm going to assist that person through their life and their passing, am I totally responsible for all their bills that they leave behind if they leave me no money?
No. As a power of attorney, you are not obligated upon their passing for their bills. The only time that can come up is if you, as power of attorney, have went out and incurred debt on their behalf by using their power of attorney and it wasn't authorized. But their estate is liable for their debts. Yes?
What happens when the individual has a direct disagreement with the power of attorney agent? For example, the agent says, you need to take this pill every morning, and I say, I'm not going to. Does the individual override the power of attorney?
Yes. And so so I don't know if did everyone hear his question? When we have a direct disagreement between the principal, the individual who signed the power of attorney, and the agent, the person who is nominated as the power of attorney. The agent cannot override the principal. If the principal really says, no, I'm not going to do that, no, I'm not going to go take another $100,000 loan out, or no, I'm not going to take that pill, then there comes times when a power of attorney, because of that, essentially becomes useless. And unfortunately, sometimes that the principal who is refusing to really act in their own best interests and listen to their power of attorney, it gets to a point where the power of attorney may have to go to the next level and go to the court and request a guardian and conservatorship, where a guardian and conservatorship is the court actually saying, of course, if they make the proper findings and there's the proper evidence, that principal, that individual who is refusing to take their medication, they're refusing to do things that are in their best interests, they are no longer capable of making any decisions on their behalf, whether it's to most commonly either Alzheimer's or dementia or some related ailment as that they need a guardian and conservator appointed. Now a guardian, if an individual has a guardian and conservator, that means they no longer have the right to make decisions on their own behalf. And so they can no longer override you.
I have a question on that.
Yes.
So a conservator, can it be a non-relative?
Yes.
Okay, so when you say guardian and conservator, can they have both?
Yes, and they're very often the same person. So with guardian, so let's be sure we understand. A guardian is the court appointing an individual to be the legal person in charge over the individuals that we call them the ward's body and their care. So a guardian is going to be in charge of determining where the individual lives, is going to have a lot more to do with their health care, is going to determine what medications they should be taking, is going to generally be taking care of them, I mean just their person on a daily basis, where the conservator has complete control over the ward's financial assets. They're paying all the bills. The conservator doesn't make decisions on where they're going to stay and live. The conservator just pays the bill for the guardian's decision. Very often those are the same individual, but they don't always have to be.
I have one more question.
Go ahead.
Can the conservator, if there's a life-threatening episode, does the conservator have the right to make those decisions to end their life?
The conservator does not, no. The guardian would. Yeah. Yes.
So the conservator and is appointed by the court.
Correct.
Does that negate the power of
Yes.
attorney and medical power of attorney?
Yes. If a guardian or conservator has been appointed, the powers of attorney are no longer in effect. From a Colorado, in the event a guardian or a conservatorship is applied for through the court system, they do generally, one part of the petition is, do they have a power of attorney? And if they do have a power of attorney, and that power of attorney is the one applying to be the guardian or conservator, the court generally gives them preference in the event it's a contested guardian or conservatorship proceeding. But if there's a third party applying to be guardian, and that's not the power of attorney, the court's going to say, is there a power of attorney? If there is, I want to hear from the power of the attorney. That's what the judge is going to say. Because the judge is going to say, at some point, this person trusted this individual, so I want to hear from them. I want their testimony. Yes?
Along that line, I'm wondering if anybody can apply for a guardianship or conservatorship.
Correct.
Anyone.
Correct.
So is there an entity by which someone might be able to say, these are specific people that I do not want or I do want considered for guardian or conservatorship?
Yes. You actually place that in your power of attorney document.
Oh, okay.
Yes.
So these people I would not want these people considered to
Correct.
be a guardian.
Correct. And there is also a lot of other, it's not just if you apply, you get it.
Oh, I know.
You know, it's a pretty involved scenario, but, and you keep raising your hand, I'm sorry.
What's a proxy? And how, a proxy? Proxy. And how is that different than a guardian?
So a proxy in the a lot of different proxies, but I'm assuming you're talking about in the medical world. Proxy is normally an individual nominated more for a very specific and limited, do you have a power of attorney? You're going in for a medical procedure, and the doctors or the people admitting you into the hospital are saying, do you have a power of attorney? No. Do you have a proxy for this, is there somebody we can contact if somebody goes wrong? It's very specific to that procedure or for a very specific purpose.
I have a question. How familiar are you with Medicaid law?
I do a little bit of Medicaid, but I am not a Medicaid expert by any means. That's a little bit more of a specialized, and that's a lot of attorneys that do a lot more disability and Social Security also deal with Medicaid. We deal a little bit with Medicaid long-term care, but not the more broad general Medicaid programs. Yes.
This is a little bit off, but could you just briefly go over the advantages, disadvantages to having a will where technically it can go through probate
Yes.
versus a revocable living trust which goes around that?
I will, and just that's a little bit later on. I'm gonna kind of get done with powers of attorney.
Okay.
And then did you 10 minutes? Oh wow. So any final questions on powers of attorney? Yes.
If you're married, does that automatically make your spouse your power of attorney?
It really depends on the medical care providers, but no, it does not. Legally, no. It does not. And I have a lot of clients actually designate a power of attorney that's not their spouse. You need, so kind of how I wanted to conclude, the power of attorney was really, there's one part about understanding what a power of attorney is. There's the other side of it, of understanding what it looks like when you don't have a power of attorney. And what that really looks like is more than likely phone calls to us, and because there's going to be fighting. Okay, there's going to be fighting. Like I said earlier, powers of attorney don't always have to be used because something has gone wrong. But generally speaking, when a power of attorney is needed, it's because there's either an accident or there is some sort of medical condition that has come up to where you need somebody immediately available to act on your behalf. And if you don't have that document properly executed and you don't have copies given to those people, a lot of cooks are in the kitchen all of a sudden, and there's a lot of hard feelings, there's a lot of emotion going on in those scenarios, and it very often leads to division in the family. It very often leads to the need for somebody to go, if you don't have a power of attorney, often leads to somebody needing to go through a guardian and conservatorship proceeding where, had a power of attorney just been done, we wouldn't be in the guardian and conservatorship world, which guardians and conservatorships are fairly expensive. Once somebody applies to be guardian and conservator, most likely they have an attorney, and then the court appoints 2 attorneys. So it's an expensive process. So I highly recommend you get your powers of attorney done, you nominate the correct individuals, you'd have discussions with those individuals, and your medical care providers, your financial institutions, and your powers of attorney are provided with that documentation. 5 minutes, okay. We're going to go a little long, is that okay? And I will get to the will versus trust here in just a minute. I know a big emphasis today and specific to hospice is the advance directives. We've gone over power of attorney, and your power of attorney will have the ability to make the decisions on your behalf. As different things could progress in your health care, eventually the powers of attorney are faced with some very difficult decisions. And although you may have had those conversations with your loved ones, you may have had those conversations with what you would want with your spouse or your children or the individuals that you have nominated as your power of attorney. I don't know if any of you have been in that position, but even though you're nominated as power of attorney, those can be very difficult decisions to really, when we're talking about either getting care or refusing care in certain situations. It's very hard for family members to make those decisions. So your advance directives are your ability to communicate really how you would want to be treated in certain scenarios, certain most likely life-ending scenarios. And you can communicate those decisions now while you're able to communicate those decisions. And that is a very, very large blessing to your family and your loved ones. And I'm sure your medical care providers can probably talk about what they see with family members going through that all the time, and the very hard decisions that are made that, you know, when you have those advance directives done, when you have your living will, when you have your most form, your 5 wishes, your DNR, that are all properly executed and provided to your medical care providers and facilities, when your kids can say, hey, Mom made this election. I don't necessarily agree with it, but while she could, she communicated what she wanted. That's a lot easier for your family members to deal with already the emotions and the trauma that they're going through than actually having to make those decisions. So we really strongly recommend the advance directives and getting all of the different, like I said, your living will, your most form, your 5 wishes, completed, executed. Some of them have to be notarized, they have to be witnessed, doing all that properly. We had a question here, and I know I don't have a ton of time, for more of just an estate planning. As Andrew made clear, upon passing, your power of attorney is no longer effective. At that point, we move on to your, really what we would consider your estate planning document, which is either no will or no estate planning document, or you can utilize a will, or you can utilize a trust. For most people, the benefit of a trust is the avoidance of the probate process. There can be other benefits. There can be some estate tax planning benefits. Right now, our estate tax level is just over 12 million, so those apply to not as many people. But if you create a trust is a legal entity, where a will is a document that says, here's who I am. If I pass, here's who I nominate my personal representative, and distribute my assets as follows. Okay, which is fine. There's nothing. We utilize wills all the time. Upon your passing, what a will look like is that individual that you nominate as personal representative applies to open your estate through the court system. They have to have your will, they have to have a death certificate, and they have to tell the court they're willing to act in that capacity. And if they do that, then technically what the court does is they open what we call a probate estate. And there are certain there's a lot of different legal requirements as part of probate. I'm sure you've all seen, maybe in the legal section of the Cortez Journal, the notice to creditors. That is a part of the probate process. There are other aspects of the probate process, opening estate bank accounts, collecting all of the assets and doing inventories that are all Colorado statutorily required as part of the probate process. So probate, it is a court proceeding. Now, most of the time, we don't really even see the inside of the courtroom in probate, but with a will, you will be in that probate process, which is technically a court administered process. What a trust would do is, if you create a trust, the biggest thing you have to understand is you have to fund it. Putting your signature on a trust does nothing until you deed or you transfer your assets into the trust. And what that does is now you don't own your assets. This entity does. And when you pass, that entity is still alive. Okay, and so because the owner of these assets is still a legally recognized entity, we don't have to go through the probate process. We can more immediately transfer assets according to the terms of the trust, because we don't have to go through the court system to open up probate to transfer them. Okay, now, so that's kind of the trust being utilized to avoid probate. Trusts don't keep people from fighting. I'm not going to tell you that if you do a trust, you're never going to end up in court. If people want to fight, they can still fight. And so a trust is not guaranteed that your things won't end up in court. And the other thing that we see quite common is individuals do a trust, and then they don't keep their assets in the trust. you know, they forget about their trust, and then they think, man, these winters here in Cortez really suck. I'm going to go buy a little place in Arizona to get out of the cold for a few months a year. They go buy the place in Arizona, and they forget to put it in their trust. So as to that asset that didn't get in the trust, we're in probate. So it's very critical that you keep all of your assets in the trust if your goal is to avoid probate. Yes?
A question on the trust. If I put all my assets in the trust, and then, I mean, that means the house, or whatever has value, right?
Mm-hmm.
And then I get to a stage where I have to go into a nursing home, but I don't have any active assets to pay for that. Can somebody come after the trust?
Yes.
So they can take it to pay for your...
Yes. Generally speaking, trusts are not a liability avoidance technique. There are trusts that are called irrevocable trusts that can be utilized as a tool to alleviate the possibility of your assets being subject to your liabilities. Irrevocable trusts are very cumbersome. You cannot be the trustee. More generally speaking, when we talk about trusts, we're talking about a fully revocable trust that you, the creator, are also the trustee. And so because there's no real division, I mean, like a revocable trust, if I put my home in it, I can take my home right out. If I put my money in the trust, I can take the money right out whenever I want. And because there's really, although it's technically in an entity, there's really no division between myself and the trust, then the trust is not effective to protect assets from nursing home liabilities or auto accident liabilities or tax liabilities. If you want to do that kind of liability protection, you've got to get it into an irrevocable trust. And there's a lot of different rules on an irrevocable trust. So, yes?
Andrew mentioned beneficiaries. Okay, if they're listed beneficiaries or recipients in a will versus what's listed on an insurance document or something.
Correct.
And they differ. Which one takes precedence?
So in the event, if you do a will or a trust or any estate planning tool, and you've got certain beneficiaries nominated in your will or your trust, but you have a different beneficiary either on your life insurance, your account with Andrew at Edward Jones, and that's not an Edward Jones specific. I mean, whatever if it's Morgan Stanley, whoever it may be, your beneficiary designations through your financial institutions, that is a contract with that financial institution. They have to honor it regardless of what your will says. If you put in your will, my Edward Jones account number, da-da-da-da-da-da, needs to be distributed to so-and-so, but you have somebody else on that account as the beneficiary, that beneficiary on the account will receive the funds. So I know we've got to move on to the other individuals. I appreciate everybody coming today. And yes, yeah.
Medicaid specific about trust and transferring properties. If you go to a nursing home and you need options for long-term care to pick up the bill, the state of Colorado would help fund that. You are not allowed to transfer property within the last 5 years. So
correct.
if you're going to go to a nursing home tomorrow, you cannot sign over your property.
Thank you. Appreciate it.